Welcome back to Organized, the business law breakdown. I'm Professor Seth C. Oranburg, and today we're wrapping up a season on corporate governance. We've talked about a lot of legal principles, but now we're going to zoom out a little and explore why corporate governance matters and why it fails. We've covered the business judgment rule, the duty of care, the duty of loyalty, the role of directors, the role of executives, how the duty of oversight fits into the picture or not, the various ways to defend against corporate takeovers and whether active investors matter. But let's step back. What is the purpose of these structures in the first place? What works in corporate governance? At the most basic level, corporate governance serves a fundamental purpose. It ensures that directors and officers make decisions that are in the best interest of the company and therefore generate profits for shareholders, the owners. But to understand why governance works the way it does, we need to recognize its economic function. The business judgment rule, as we've discussed extensively, is not just a legal shield to protect directors. It serves an economic function. Let's think about it. How might a business judgment rule change behavior? Well, the protection against stupid decisions encourages directors to take risks. Because let's be real, businesses are all about taking risks. If a company isn't willing to take risks, it's not going to get rewards. It's not going to innovate. It's not going to grow. Ultimately, it's going to fall behind. The business judgment rule exists to encourage directors to make decisions without being fear of being personally sued for every decision that doesn't turn out well. From a public choice perspective, the business judgment rule works. It aligns the interests of managers who need to make decisions with shareholders who want to see growth and returns. It's a rule that provides certainty that directors make strategic decisions that have high risks and high rewards. So if you want high risks and high rewards, you invest in corporations. So in that sense, it works. It encourages a certain kind of decision-making that benefits this kind of organization. But where does it go wrong? Where does corporate governance fail? This is where we get into the messy reality of corporate governance. The business judgment rule works in clean economic theory, but it's not a silver bullet. It's up to directors to make sure they're informed, engaged, and diligent when making decisions. And shareholders need to pick smart directors. That's where things start to fall apart. When we look at failures in governance like Enron or Wells Fargo, we often find that directors weren't doing their job or weren't up to the task in the first place. In Wells Fargo, for example, we saw board members who were clearly disconnected from the company's actual operations. They didn't understand how their sales culture was pushing employees to commit fraud. The board wasn't actively asking hard questions. They didn't even know the questions to ask. And as a result, when the scandal broke, they failed miserably at fulfilling their oversight responsibilities. This is an example of a governance failure. It's not a problem with the business judgment rule per se. It's a problem with the board's engagement. There are a lot of reasons that people pick board members, and it's not always because they ask hard questions. One way you get on the board is get along with people. They weren't watchdogs the way they were supposed to be. And this is a critical point. Corporate governance only works if directors do their job, which includes asking tough questions, being unfriendly to management, understanding the business and holding management accountable. If they're asleep at the wheel or too cozy with management, that's when things fall apart. And given that they all play golf at the same country club in Martha's Vineyard, we have some questions about whether that really works in practice. So let's talk about the economics of corporate governance. Let's take a deeper look at why failures happen. Let's take an economics and public choice perspective on the question. At its core, corporate governance is about balancing the interests of different stakeholders. Some stakeholders, like employees, want salary. Other stakeholders, like shareholders, want profits. Other stakeholders, like directors, want autonomy and to avoid liability. Managers want to run the company in a way that keeps them in control and motivated and flying corporate jets. But these interests don't always line up. When boards fail to properly monitor management or fail to diligently assess risk, they essentially ignore the economic incentives that drive companies to make smart, high-reward decisions. And that's where agency cost comes back in. Directors and officers have their own incentives, and their incentives don't always align with shareholders' incentives. That's where agency theory comes back into play. Agency theory explains why managers might make decisions that benefit themselves but not the company. For example, managers might push through executive comp packages that benefit themselves even when the company is underperforming. They want more money, right? In Revlon, the court said that once a company is up for sale, the board's duty shifts from maximizing shareholder value to making sure the sale happens at the highest possible price. But what happens when the board gets cozy with one bidder or conflicts of interest arise? That's where we get back into agency costs, when the board's actions are misaligned with shareholder interests. Let's be clear, corporate governance doesn't work when the board isn't doing its job, if they don't understand the business, if they're too loyal to management, or if they're asleep at the wheel. A failure to monitor or engage means the board is not fulfilling its duty to ensure the company is being run in a way that's in the best interest of shareholders. The lack of engagement leads to a breakdown in oversight and puts shareholders and other stakeholders at risk. And it's not just a theoretical problem. This really happens. In the case of McDonald's, the board failed to properly address sexual harassment complaints. It led to legal and reputational issues for the company, sure, but people also got sexually harassed at work. The failure to take action is an example of poor governance that costs companies and societies dearly. So look, corporate governance is not a perfect system, but it's a system we have to make sure directors and officers are doing their jobs properly, and that they're held accountable when they don't. As we've discussed, key elements are diligence, engagement, and oversight. If the board's not involved, then corporate governance fails, and everybody suffers. Shareholders, employees, the public. We've learned a lot this season about what works and what doesn't, but the bottom line is that corporate governance is a constant work in progress. Just because something is in place doesn't mean it's going to work unless it's executed correctly. Next season, we'll dive into shareholder litigation, the next step in enforcing the rights that corporate governance grants to shareholders. But until then, I'm Professor Seth C. Oranburg, and this is Organized, the Business Law Breakdown. Thanks for listening.